and thank you for joining the Florida Center for Students with Unique Abilities monthly informational webinar, Guardianship and the Alternatives. My name is Drew Andrews. I'm the Assistant Director and Technical Assistance Coordinator at the Florida Center for Students with Unique Abilities. Our presenter today is Catherine Davey, Counselor at Law. For more than 25 years, Catherine Davey has practiced law. She focuses her practice in probate, guardianship, guardian advocacy, estate planning, and the drafting and implementation of special needs trusts for individuals with physical and developmental disabilities. She received her Bachelor of Arts from George Washington University in Washington, D.C., and her Juris Doctor from Stetson University College of Law in St. Petersburg, Florida, and her Master's of Law in Transnational Business Practice from the University of the Pacific McGovern School of Law in Sacramento, California. Handouts for today's presentation can be downloaded from the chat section of the Zoom, and that's the little speech icon down at the bottom, as well as a lot of other links that Catherine has provided for us. This webinar is being recorded. If you have difficulty hearing the presentation, phone numbers that can be used to call and join the audio via phone while following the slides online will also be posted in the chat window. At this time, I'll turn it over to Catherine.
Hey guys, good afternoon. I hope everybody's day is going well so far. I'm delighted to be with you and presenting again on my favorite topic. So I am indeed Catherine Davey. I'm a Florida native. I was born in Jacksonville, raised in Orlando, went to high school here and then went off to college, came back to start practicing law. And my husband and I have 3 daughters. Our youngest has Down syndrome. So excuse me, you see May right in front of you. She is the reason I am here today. So what I always tell people is I was a very good lawyer before. I loved what I did. I was passionate, but then May came along and she changed everything, right? So not only am I a person who practices in this area of law, but now it's very personal to me because as a parent of a child with special needs, I hear the fear and misinformation that's so often parlayed into the special needs community and to the parents of children with intellectual and developmental disabilities. And it became my mission and calling to make sure that the information that was provided to them was as accurate as possible. I always tell people that I have one goal in life and it is change the world for that little girl, but I have really big coattails and I'm happy to change the world for all sorts of other people as well as I work to change it for her. So. All right, so let me tell you what we're going to talk about today because I know you are interested to hear some of this because I'm sure this comes up in your work all the time. How can I help students and their families with an intellectual or developmental disability after they turn 18? What are some common fears and solutions to those fears? What are the options available for those students and their families? What is supported decision-making? Versus what is a durable power of attorney, healthcare surrogate, and other documents like that. What are the differences between a guardianship and a guardian advocacy and a partial guardianship or a limited guardianship? And the process of guardian advocacy in Florida, next steps, and what else should I know? There will be points where I would love to have conversation from you guys. Typically, if we were doing this in person, I would literally just have you shout out and I'd be happy to answer questions. It's easier if you guys put your questions in the chat in this reality, and I'll definitely save some time at the end so that we can address those questions. And I'll also have things that I pose to you all as well, because it's one thing for me as an attorney to do things in the courtroom, but then what I've learned is some of the stuff we do actually causes problems for you guys. And that is, of course, not our goal. So I'm open to solutions as we work through those issues. So, all right. So what are some of the common fears that I hear in the special needs community? And you guys have probably heard a lot of these too. So that their children will be exploited or taken advantage of somehow, right? We all know those statistics and they're pretty grim about how often that happens in the special needs community. That their children won't be able to manage their medications or make their medical decisions. that doctors will no longer talk to parents or allow them to continue to make medical decisions for their child or their loved one, that no one will help their child as a student or let the parents continue to be involved and help them. That parents can no longer advocate for their child or protect them, or parents can no longer advocate for them at school. So how can we allay some of those fears? Well, I mean, in the context that maybe you aren't dealing with on a regular basis, but one of them is credit theft, right? And so credit cards, you absolutely can freeze someone's credit where it's allowed. If the doctor won't talk to parents or discuss treatment options, if the person has the capacity to execute a release of information or a HIPAA release, they can do that. If they're concerned about that there will be no one to act for their child after their lifetime, don't forget estate planning. Moms and dads are so focused sometimes on the near term that sometimes we forget the long term as well. And sometimes their kiddos have behaviors and issues, and the parents can't always protect them. So through the Orange County Sheriff's Department and other organizations, there's all sorts of ways we can do that to help identify a person as having an intellectual or developmental disability. And that parents won't be able to talk to educators about some of the special needs of their children or issues that their child may be addressing. And I've heard that many times in many forums. There are authorizations, as you all well know, that they could sign off on, but sometimes, you know, things get lost in the mix and parents get scared and frustrated, and it's challenging for everybody because there's so much fear-based in what they're dealing with. So what are the options? In the state of Florida, or generally, supported decision-making, we'll talk about that, substituted decision-making. And so substituted decision-making is what typically all of you should have, right? You should have a financial power of attorney, a healthcare surrogate, and documents like that. It's also possible to do a guardian advocacy and a guardianship. All right. So the Florida Developmental Disabilities Council gives us this great visual of from least restrictive to most restrictive. All right. Although a bill was presented to the Florida House this year on supported decision-making is not the law in the state of Florida. So I'm not saying it doesn't work. It's not possible. But it is currently not the law in the state of Florida. So if somebody tries to tell you that it is, that's not correct. And then at the top, the most restrictive aspect is guardianship, right? So it's from the bottom least to the top, it's most restrictive. All right, so supported decision-making. It's a tool that allows, and I'm just gonna read this to you briefly, but I want you to, you'll conceptually follow with me in a second. It's a tool, typically a written document, that allows people with disabilities to retain their decision-making capacity by choosing supporters to help them make choices. Okay, so I want you to think you were 18 years old or whatever, and you were going to buy your very first car, right? You didn't go by yourself. You didn't just go, woo, I'm gonna go to, you know, Holler Chevrolet and pick out my favorite car and sign off on all the documents. Likely your mom and dad went, maybe your uncle went, maybe you had a whole tribe of people that went with you to make sure that the car was a good car, to make sure that the financing made sense. And all those people helped you through those big decisions. So that's sort of functionally what supported decision-making it is. You have a little tribe, and that tribe helps you with specific decisions. Maybe your mom is the one who helps you with healthcare decisions. Maybe your dad is the one who looks over things mechanically, or vice versa. And it's that kind of process. It can absolutely be done in writing as well, so that people know who has which jobs. And there's all sorts of information I've added to this screen, so that if you want to learn more about supported decision-making, you absolutely can. There is a huge movement, obviously, to make this the law in Florida. I do not anticipate that this is the last time we'll have heard from this in this Florida State Legislature. Developmental Disabilities Council is very adamant that this, they continue to pursue this. So you will continue to hear more and more about this. All right, a durable power of attorney. So conceptually, a durable power of attorney is, I want Drew to handle my financial affairs if I'm sick and I'm in the hospital, or I'm on a trip around the world. So I prepare a legal document that says all those things, right? If these things happen, then Drew's to handle my financial affairs, and these are the situations very specifically where Drew is able to act on my behalf. All right. It has to be signed in the presence of 2 witnesses and a notary. It's a whole big thing. There are specific rights in that power of attorney that have to be initialed because they're superpowers. It is a whole process. And if you're downloading forms from the internet, shame on you, because good luck, that's probably not going to work, or it won't work at the very worst, most inopportune time. Lawyers draft these all the time, and we change them all the time because the law changes and things change and things go sideways. So just like you get better at your job every day, so do we, and we learn lots about what needs to be changed and amended to make everything from banks or other institutions happy with us in the documents that we draft. Typically, powers of attorney, the way I define them, is just about money, right? So I always do that little hand thing, so it's money. So I want you to remember, typically powers of attorney are money. Now, I've had, and back in the early days when I first started doing this, people ask me, could a person with an intellectual or developmental disability sign a power of attorney? And frankly, I wasn't too sure, but the answer is, of course they can, right? If they have the capacity to understand the document. So that's, you see the line. Yes, the principal must understand the power of attorney document when it is signed. The principal must understand the effect of the power of attorney, to whom the power of attorney is being given, and what property will be affected. So I can't tell you how many of my typical estate planning clients come in and go, oh, I don't understand. It's so many words, like, I'm just going to trust you because I don't know. It's so complicated. Well, frankly, I don't let those people sign the documents until we talk them through pretty thoroughly. I get that what I do sometimes reads like stereo instructions, but I got to have you understand it enough to get through it. And that's the same is true for a person with an intellectual or developmental disability. Do they need to be able to understand every word? Do they need to be able to implement this personally? Do they need to be able to draft them themselves? Absolutely not. But they have to understand conceptually what the power of attorney does, who they're giving the power to, and what property might be affected, right? I have a bank account, I have a car, I need Drew to file my taxes for me. Whatever it is, I need to generally understand how this works, okay? Okay, and it can be very specific as well, but typically in a situation like this, we're talking about broad powers of attorney. All right, healthcare surrogate or a patient advocate. This is healthcare decisions, right? So I hold on to my shirt like this because it's your physical person. So I'm sick and I'm in the hospital and I want Doug to make healthcare decisions for me. Won't my family be surprised that I've randomly picked Doug, but I've already talked to Doug a little bit today. So Doug wins that prize. So I'm sick, I'm in the hospital. The doctor comes running out just like they do on TV and says, her spleen has to go. Doug, you have to consent to this. The good news is I've done a document in writing that said, Doug's the one. If Doug, if I can't make a healthcare decision, if my spleen has to go, I want Doug to be the one to make that decision. All right. So every competent adult has the right to make decisions concerning their health, including the right to choose or refuse medical treatment. So just because I disagree with what the doctors want to do doesn't mean I'm incapacitated, but they have to be able to understand conceptually and sort of specifically, right, how all this is going to work and what the consequences are of not consenting. So again, they have to be able to understand the document. Not can they sign it, because people tell me all that all the time. Oh, they signed the document. Right, I understand. But did they understand what they were signing, right? Did they understand how it was going to work? Did they understand that if you can't make a decision, Doug's going to make it for you? And if Doug can't make it, then I'm going to have Janice make it, right? They have to be able to understand it. All right. Oh, come on. What a nugget. So a little older picture of my sweet girl. So the answer is, and just, the Down Syndrome Association of Central Florida always puts on a fundraiser. And, we're a little bit competitive about these things, as you could imagine. And of course, this year, if you can't tell, the theme I had for her was Rosie the Riveter. So that's why she's dressed up the way she is. And we raised great money for the Down Syndrome Association. All right, but what's the right choice for your loved one, right? We've talked about supported decision-making and substituted decision-making. And why do you even have to do this, right? Now, you guys will have run into this many, many times. Prior to the age of 18, everyone is presumed by law to be incompetent. So although my 15-year-old is confident that she could run the world if they would just let her and be a fairly benevolent dictator, but not always, she is actually incompetent right now. But when she turns 18, God help us all, she will be presumed to be competent unless the court rules otherwise. Now, that's not my daughter with Down syndrome. That's my typical daughter who, trust me, will be a benevolent dictator, we hope. All right, so that's how it works. At the age of 18, magically, we are all presumed to be competent, whether we are or not. Okay. All right. So how do you decide what's right for your kiddo, for your loved one? So we've given you 2 great hyperlinks so that you can work your way through the process. I have seen others that are fairly self-serving that drive every single person into a guardianship. Please don't use those. Not everybody needs a guardianship, and it makes me sort of batty when I see people do that. There's all sorts of options for all sorts of people because we are all different and we are all individuals, and not any one answer is right for every single person. So think through that and offer these suggestions, because I want people to really be thoughtful as they make these choices. And I'm going to say this now, but I'm going to say it again. And just because this is the right choice now doesn't mean that 5 years from now or 10 years from now, it remains the right choice, right? Life changes, people change, we all change. You know, sometimes choices have to change too. All right. So I wanted to give you just a little glimpse of what the Exploring My Decision-Making Options Toolkit looks like. It was created by the folks at, we call it Florida Wings. Everybody loves an acronym, just like you guys do. Florida Working Interdisciplinary Network of Guardianship Stakeholders. I want you to think lawyers, judges, all sorts of people connected to the guardianship world. All right. Obviously, if I were doing this in a presentation, you couldn't read any of this, but you're sitting at your own desk and you can see my PowerPoint pretty clearly. So it goes through various categories like self-advocacy, employment, money management, and it helps you literally think through with your, and you sit down with your loved one. I will sit down with May when she's 18 and do just this. In terms of self-advocacy, can I express my own choices and preferences? Oh goodness, she can do that now. Like I could check that box right now. No need for support. Like she is very clear. Can I ask my family, friends, or circle of support for help? Yeah, she could. She's usually pretty quick to do that. And it goes all the way through parts that may actually make you a little uncomfortable, right? Because there's choices in relationships about, can I understand the need to consent to sex, right? There's a whole movement in the special needs community about having that conversation. Like our kiddos are going to grow up, our kiddos are going to do what everybody else does. And I have another college student and I don't want to think about that. So, but I know, you know, college is college. I was there too. Y'all were there too. So I want parents to thoughtfully work their way through this and to have their loved ones sit there, and I'll sit there with May and work my way through this. And this will help me decide, or help us decide, what's best for her when she's 18, right? And again, maybe we look at it again later when she's 21 or 25, and we continue to think through this. All right, so we're going to make a decision, and let's say that when she turns 18, we've worked through the questionnaire from the Wings decision-making toolkit, and we think guardian advocacy is right for her. What is a guardian advocacy? All right, in the state of Florida, of course, it's different in other places, but in the state of Florida, sometimes you'll hear it referred to as like guardianship light, right? It's not all the ugliness and hardness of guardianship, but it's some of it. But it really only applies to people with developmental disabilities. Literally had a case come in yesterday where the person was in a car accident at 14, suffered a traumatic brain injury. Can I do a guardian advocacy for that person? No, I cannot, because a car accident with a traumatic brain injury is not a developmental disability. They were not born and it was not identified prior to the age of 18 that they had a developmental disability. Something happened to them. That's different. Typically, only certain rights are taken away, not all. That's actually what's physically in the statute. We're working on some of those things because some of those things don't exactly make sense, but that's how it's drafted right now. It can be both of the physical person as well as the property. And if it includes property, then the petitioner, typically mom or dad, or mom and dad, must have an attorney. Right? So if there's money, there's got to be an attorney, because we got to make sure people don't steal from you or steal from the person with the developmental disability. If you're seeking guardian advocate of the person only, then the petitioner or guardian doesn't have to be represented by an attorney. So I've done a huge amount of work in this field, in this very specific area, to make sure that there's forms and systems and processes. Heck, I've done spreadsheets, charts, graphs, everything I can. I've even done scripts so that families can get themselves through this process without having to hire an attorney if they can't afford one. I certainly understand that. What I do is very expensive. What I do has a lot of liability attached to it. There's a reason I charge what I do. I've been doing it for nearly 30 years, and it's hard work and it's challenging work. But not everybody can afford that, and not everybody needs that, right? So I try to make sure people can do what the statutes intended them to be able to do. A guardian advocacy is different from a guardianship in that there's no determination of incapacity. All you do is get a letter. So what I would do is get a letter from one of May's doctors, whether it's her pediatrician or her, whichever doctor, that she has a developmental disability, right? She has Down syndrome that manifested prior to the age of 18. Obviously, she was born with Down syndrome. It didn't come later. And that the individual is unable to handle her own personal matters related to finances and her physical well-being, right? So we're going to say that at 18, maybe May can't handle her money, right? Or if she got SSI, or if she had a job, is it possible somebody could take advantage of her or steal her money? Or would she be able to make healthcare decisions for herself? Tough to tell, but for the sake of discussion for this, let's say no. And that they need the assistance of a guardian advocate to meet the essential requirements for their physical health and safety. Okay, so it's that letter from the treating physician that they're going to submit to the court is going to say all those things. All right, so I've given you a copy of the statute just so you've got it. Person with a developmental disability must not be presumed incapacitated solely by reason of his or her acceptance in non-residential services, right? Or admission to residential care. So just the fact that they're getting services from APD or somebody else doesn't mean that they're incapacitated, and it doesn't mean that they're not entitled to make their own decisions. And that there's going to be a hearing typically. I will tell you, in COVID land time, they're not always having hearings. Sometimes they're just entering orders, but it's usually in pretty clear-cut cases. And again, I told you before, and here's the information, without an adjudication of incapacity. That's important because that triggers other things in guardianship land. Maybe not important for you guys, but certainly very important to us. All right, advanced directives for healthcare and durable powers of attorney, still absolutely appropriate. And it can be a very limited guardian advocacy if they've already got these things in place and they were actually properly executed. Again, it's not, did May just sign them? It's, did she understand them when she executed them and what they would do, right? That's critical. So it limits what the guardian advocate can do if those things are in place. All right, so intellectual disability manifested prior to the age of 18. There is a list that comes out of chapter 393. That's part of the reason I give you 393, so you know where to go and look for all this fun stuff. The list of 6 that come out are, so it's intellectual disability, right? So I want you to hear that as its own kind of umbrella group, because what this statute doesn't do, for reasons I don't quite understand, is, as you all know, there's lots and lots of other genetic and or other developmental disabilities that are not listed within these 6. So we sort of drive everything else into intellectual disability manifested prior to the age of 18, right? We call that kind of the umbrella group. Other than that, it's ASD, cerebral palsy, Down syndrome, Phelan-McDermid, Prader-Willi, and spina bifida, right? All 6 of those guarantee you the opportunity to go into a guardian advocacy. That's not to say that if you have those, you have to have a guardian advocacy. I'm going to tell you the story because it makes me batty, and I will follow up with this nice young man who's a baby attorney. He reached out for some help on how to manage a probate case. I was happy to do it, looked at his website, and he had language on his website that said, if you have a developmental disability, you must have a guardian advocacy. That, of course, made me a little cranky. So I called him on the phone and chatted with him and said, I just want to point out that that's not exactly true. And I come from a place of love and passion, right? I've got a kiddo with Down syndrome, so that's why it's important to me. So if I'm the tiniest bit strident, also known as I'm real strident, I want you to know that's why, right? And he goes, well, I understand because I have cerebral palsy. And I said, oh, okay. So based on your website, should I talk to your mom or your dad about your law firm? because you've just said that every single person with cerebral palsy has to have a guardian advocate. So clearly you're not running your own business, and clearly you're not the attorney. Clearly I have to talk to someone else. He was not delighted to have that conversation with me, as you can imagine. He was the tiniest bit offended. I have followed back up with him twice because he has yet to update his website, but that makes me cranky when people give out inaccurate information and scare families. So just remember, just because you got these things doesn't mean you have to have a guardian advocacy. May absolutely be high enough functioning at the time that these things come to pass or be important that she can make her own decisions. And trust me, she is a Davey girl through and through. We should all be just a little bit frightened, but she is a very strong-willed child. All right, guardian advocacy. Typically, the rights that can be taken away in a guardian advocacy of the person include, and these are the ones that are typically done in Central Florida. It's true all over the state. Sometimes the rights are broader that are taken away. There's a larger list you'll see in a little bit, but these are the ones we most typically see. All right, the right to determine their residence, the right to consent to medical, dental, and surgical care and treatment, to make decisions about their social environment or other social aspects of the person with a developmental disability's life, to act as representative payee for government benefits, okay? All right, any of those cause you any problems? Because I think probably one for sure does, and it's this one, right? Letter C here, to make decisions about their social environment or other social aspects of the person with a developmental disability. You guys have any problems with that? I'm going to put a pin on that, but I know it does, and we'll talk about that later because I'm sure you're going to throw me some questions in the chat. And if you don't, I'm going to tell you what I've heard. All right, so this is kind of what you think of in a typical guardianship, right? Dad or grandpa, he's getting older, he's maybe slipping a little, he's forgetting things, maybe he's had a couple small car accidents, he's forgotten some things on the stove, maybe he doesn't take his medication the way he should. And that's kind of what you typically think of as a guardianship. All right, so different than guardian advocacy, in a guardianship is incapacity for any reason. Could be Alzheimer's or dementia, an auto accident. It could even be for children, right? The picture I've just given you is of an older man, but we also do guardianships for minor children, sometimes when they either inherit money or something happens that triggers the requirement for a guardianship. Again, guardian of the person is that medical social stuff, right? The physical person versus property, which is money and government benefits. Any or all rights can be taken away from the protected person, right? So that laundry list that I'm about to tell you in a guardianship versus a guardian advocacy, where I can only take a few, but I definitely can't take all. In a guardianship, I can take everything away. Both the guardian and the protected person must be represented by separate attorneys. Okay, so just like on TV, when there's a criminal and the court appoints an attorney for them, it's the same way in guardian advocacy, or in both guardian advocacy and guardianship, right? Is that we want to make sure that if I'm trying to take all of May's rights away, or actually, sorry, Drew, you're up again, because at least I can see your face. So we've got real concerns about Drew. Drew's been doing some interesting things and we're concerned. So, or Drew's just inherited a lot of money that I want access to. So for nefarious reasons, I'm now trying to do a guardianship over Drew. So Drew's going to get an attorney appointed for him. And that attorney is going to both represent Drew, work with Drew, and talk to Drew about what he wants. He may say, you know what, she's right, I'm starting to struggle a little bit, or what? She is after my money. Get her away from my money, right? I've seen it both ways. You know, you never can tell. All right, so, but everybody gets an attorney because we're not going to take anybody's civil rights away without representation from counsel. All right, requires the court determination of incapacity of the protected person. I can't just say Drew's crazy, or, you know, sorry, Drew, that Drew lacks capacity. I actually have to prove that Drew lacks capacity, and the court's going to enter an order determining that. Okay, so again, I have my list that you've just seen before. All right, so here starts the laundry list, and this is the full list. To personally apply for government benefits, you saw that one before, but the right to contract, right, which may or may not seem important, but Drew can't hire a lawyer for himself if he lacks the right to sign a contract. And that becomes really important. To sue or defend lawsuits, all those car accidents Drew's been having, now we've got all these lawsuits. And to manage property or make gifts. So Drew's got all these friends coming over. He's got the yard guy who's trying to put the finger on him because he really needs some help. It's all of that stuff, right? Where we've got to make sure that we can limit Drew's ability to just give all his money away. Drew currently is living in his car because he can't manage to pay rent or keep things organized. So maybe somebody else needs to decide where he gets to live. I'm really sorry, Drew. I am making your life a hell here, babe. All right. To consent to medical or mental health treatment. You know, the hardest cases I have sometimes are the people with severe mental illness. It is very challenging, but we need to be able to make decisions for those people sometimes because they are not able to make those decisions. Again, the right to make social decisions. Drew's best friend in the world is his housekeeper, who's now become entirely too friendly with him, who again is putting the finger on him for cash. So sometimes we have to limit their ability to make social decisions. Again, the housekeeper is now thinking not only does she want to be his best friend, but if Drew is not already married, he may have a new wife in the housekeeper. Seen that many times as well. The right to vote, the right to travel, the right to have a driver's license, as well as to seek and retain employment. All right. So there is a whole big, hairy, expensive process that comes with guardianship, and it includes the appointment of an examining committee. So whereas in the guardianship, I'm just going to get a letter from May's treating physician, her pediatrician, that says that list of 3 things. Instead, Drew is going to be examined by 2 doctors and a trained layperson, in addition to having his attorney represent him. And there is a massive difference in costs between guardianship versus guardian advocacy, as well as not just the cost to establish it, but as well as the annual expenses, right? Because we're trying to make sure we're doing the best things for, sorry, Drew, I'm going to stop with you. So we're back to Doug. We're going to make sure Doug's under control. And we've got and it takes quite a while to get a guardianship established, between 3 to 5 months. We can do it a little faster if there's an emergency, but an emergency has to be a genuine emergency. Not we think one day Doug might wander off and do something, right? It's, you know, his house is being foreclosed on right now. The house is, you know, there's lawsuits been filed and he's giving all his money away to the housekeeper. All right. So we have some similarities between guardianship and guardian advocacy. And some of this is what makes parents crazy. And I certainly understand, but I didn't create this system. The best I can do is educate you on educate you on it and make it easier for you. But that's why I also say, don't assume guardianship or guardian advocacy is the right choice for everyone, because not everyone has to go to court. Not everyone should want to go to court. All right. But if you have to, if guardian advocacy or guardianship is appropriate, you're in the court system, right? And you're in the court system for life. As long as the person is alive and incapacitated, they're in. So parents will say to me, what? Do I have to go to court? Yeah, you do. Yeah, you do. There's an attorney for the protected person, like in a criminal case. Yep, because you're taking Doug's civil rights away, right? Maybe he wants to marry the housekeeper. Okay, maybe that's okay. And actually you have to complete an application, which again, I've had parents be incredibly offended by. I am May's mother. I shouldn't have to apply for this. It is also super invasive. They ask for a 10-year history and a background check. You even have to have a criminal and a credit check, as if. So there's a guardianship education class, which also ticks people off, but it's not about how to be a parent to May or, you know, a person with an intellectual or developmental disability. It's about how to fill out the forms the court wants. Annual filings. What? Will this never end? Nope. Not as long as May's alive and there's a guardian advocacy in place for her. You will absolutely be filling out annual forms every single year. And if you don't, the court gets super angry and can both remove you as guardian or guardian advocate for your loved one, but they can also find you in contempt of court and put you in jail. So I don't say any of those things lightly, but I want you to get the courts take this very seriously. They recognize that many of these people are what's termed as vulnerable adults, and so they take protecting them quite seriously. However, rights can be restored. I always tell this story, and I actually just had another hearing on this young man's life today. There was a young man with Down syndrome. His parents at 18 had him declared completely incapacitated. They put a guardianship in place and took every single right away from him, that whole laundry list. Probably not necessary, but that's what they did. So they contacted their local Down syndrome association and said, but wait a second, he's fallen in love and he wants to get married. And we're great with that. We like her, we like the other family. We think he can do it. We think he's now at 25, he's matured enough that that's actually appropriate. Okay. Like, just like a person in a coma wakes up, people grow up and mature. They may not have been mature enough at 18, but that doesn't mean that they don't become so. So what we did for that nice young man was we petitioned the court to have his rights restored. It was a single sheet of paper I filed with the court. A doctor examined him and gave him back a whole laundry list of those rights, including the right to marry. And so I have precious photos of he and his bride. Sorry, I just think it's lovely. So, all right. Next, can things change in the future? We just talked about that. Guardian advocacy may absolutely be appropriate now, but they may need to transition the opposite way in the future. Things could absolutely get worse as well. Really sorry. So I have several guardianships that I'm doing for, in this case, it's actually 2 gentlemen with autism who unfortunately like to make scary phone calls to like police stations calling in bomb threats. So just like you see on TV, I need to make sure that they don't have the capacity to form that criminal intent. So I'm having them determined to be incapacitated now, so that if they ever did, and if they were ever criminally charged, it is very clear they don't have the capacity to form that criminal intent. So we talked about my story of the gentleman who had his rights restored. And what if I decide I don't want to be the guardian or guardian advocate anymore? Can I just quit? Of course not. Once the nice person in the black robe makes you anything, you can't just quit. However, you can petition to be discharged, but you can also make sure that there are people behind you, right? This is my Miss America and the first runner-up illusion. So I'm going to be May's guardian advocate in the event I am unable or unwilling to fulfill my duties and obligations as Miss America, aka her guardian advocate. I will absolutely make sure that there is a standby or a successor guardian advocate who could act for her and help her, or after my lifetime, right? And so that's my Miss America first runner-up. That way you'll never forget, right? Right now I've got the crown, but it may be somebody else gets the crown later. And all of those things can be petitioned for in that guardian advocacy. We always talk about what the judge's expectations are. And judges are getting better and worse depending on the judge and their experience in the IDD community about how to handle this and how to talk to families and loved ones who have IDD. You know, I try not to be twitchy and emotional about this, but sometimes I am because it's really personal to me. So they talk about, do you have to go to court? Yes. You know, what should you bring? Bring copies of the documents. You know, what's the judge going to say to you? How are they going to act? I've worked really hard, both in working at the kind of state level to teach the family, I'm sorry, not family, but probate and guardianship judges, how to even deal with our population, right? I don't want them to say unkind things to the parents or thoughtless things, but sometimes I get it. You know, it's the elephant in the room. They don't want to say the embarrassing thing, but sometimes they still do. What if you've forgotten something? What if you've forgotten to do something? Generally, the judges are really, really kind about this. They understand it's scary, especially if you're representing yourself. They would not be as kind to me because I have done this for a long time. If I make a bunch of mistakes, they are not kind to me. They probably should not be, because in theory, I know what I'm doing. But if you're doing it yourself, they'll generally be very kind. Like I said, right now with COVID times, they're not even always having hearings. Sometimes you just get the orders and letters in the mail. But if there's a hearing, it's generally very brief. It's less than 15 minutes. And some things you should and shouldn't do is please don't dress badly or weirdly. Like, nobody wants to see your swimsuit or your whatever. Like, what I try to tell people is dress like you're going to church or to some nice event. Even if you're appearing by Zoom, please don't be laying in bed in the dark eating. Like, please, just so creepy. But I know you guys are I'm preaching to the choir because you guys have lived the dark days of talking to people on Zoom as well. So, all right, well, what are the next steps? All right, determine what is right for the individual and their family, right? That's why I gave you the questionnaire, so that you could think through, or the parents can think through what's the best choice, right? If guardianship is best, then you have to have an attorney, right? It's not like guardian advocacy where you've got options. If guardianship is it, that's what you got to do. If guardian advocacy is best for the family, then consider the following. Can they do it themselves? Maybe. I mean, I've tried very hard to make it as clear as I can. Maybe they just want, maybe they think, oh, I can do it myself, but I just need to have somebody look at the paperwork for me before I submit it to the clerk of court. Or does the family need an attorney to do the whole thing, prepare all the paperwork, but then they feel like maybe they got the rest? Or do they think, really, like my mother would say, soup to nuts, they need help doing the whole thing? Or if they think, you know what, May's pretty high functioning, like she's mostly got this, like I think she could execute a power of attorney or a medical proxy or healthcare surrogate. Okay. But then I strongly encourage families to use attorneys to prepare these documents, because I really hate the crap that I see downloaded from the web. I find it terrifying and slightly miserable. And the most expensive probates and cases I've ever had are usually tied to people downloading crap from the internet. If supported decision-making is the right choice for the family, then research how to make that work and possible for them. And that is it. So here's my contact information. I am happy to answer any and all questions. I have no idea how to get the chat questions so that I can see them. Mr. Drew, I return you from incapacity and all the problems you had a few minutes ago. Do we have questions in the chat, or are people like, I have got this, I can now practice law doing this? Oh, you're on mute.
Maybe what you said wasn't all incorrect. Here's one question. Okay. Let me go to the very top and see.
Maybe if I stop sharing the screen, I can see the chat.
You could, yeah, you could stop. You could do that.
Stop sharing.
And then we can, I was just looking to see where it started. I was going to start at the bottom. There was a question. Yep. Okay. Where's Catherine's email address? Oh, hopefully you saw that. If not, here you go.
I see the question. It asks, who takes over the guardian advocacy role when the designated person or persons, maybe parents, have passed or are no longer able to do so?
Okay. So, you know, I've gotten older. I'm no longer able to act, and I can't quit, right? I've got a petition to be discharged, and hopefully I'll have got all that organized. But somebody else could petition, whether it's to my other two daughters or a family friend, like somebody else would stand up and say, oh, somebody's got to help May because she can't do what she needs to do. Now, it certainly happens that people do die, right? We've had guardians die. So we file their death certificate and then petition to have them discharged. I know it seems funny, but we still have to discharge them. Excuse me, that's the process. And then we, and then we would get someone else appointed. All right. All right, hold on. Let me go back to the top and do this in order. Yeah, let's see, link to the handouts. I'd rather have power of attorney. I'm sure you would, Doug. I feel that of you.
Doug also has a question. What is the relationship between guardianship and student privacy rights under FERPA?
Yep. So I saw that question. I was actually trying to go in order from the top to the bottom, but
okay.
That's okay. The relationship between guardianship and student privacy rights, I can't say I've had that experience personally, but guardianship gets, depending on what the rights are that are taken away and the rights that are assigned to the guardian. Let's just say it's a plenary guardianship or a total guardianship, then the student has no privacy rights, right? Everything's been assigned to the guardian. And it may be that that may be true in a guardian advocacy as well, depending, because right to education is something that can be taken away, or the right to, just like the right to seek employment. But generally, okay, sorry, so I'll answer the question more generally. So in a guardian advocacy, just pretend all I've taken away are those 5 rights. Hold on, now I'm going to lose the chat again, but I'm going to share the screen again because I want you to see this. Okay, hold on. Let's go back to my list. Okay, right, you guys can see this? There you go, there's the list. So if I've given, or if May has lost those 5 rights, those 4 rights, okay? then the law says everything else she keeps. Okay. So the only things I control in a guardian advocacy are those rights that were taken away from her and assigned to me. So she may still have those rights, but that could become problematic, you know, if mom and dad needed to have those student privacy rights assigned to them so they could help do things. That is a great question, Doug, and I knew you were a troublemaker, and I will definitely keep track of that and raise that in my world, and I'm making a note. And it's not just.
I've been trying to get a clear answer. Looking through our.
But that's the answer. Any rights not taken away and assigned to somebody else stay with the person.
That should mean that they have the FERPA rights, because everybody in college is assumed to be an adult, apparently under FERPA. So even if they're a high school student, if you're attending college, from the university's point of view, you're an adult, and we're just trying to make sure that we are following the law. And it's.
Yeah, no, I understand. And that's a great question. I will go chase that down further. And I'm on the guardianship. I used to be on the probate rules committee. Now I'm on the guardianship committee. And we're working on all these things. So I'm also working on a rewrite of chapter 393. So I will circle back because I think that's really critical, because if May's going to, you know, should she reasonably, let's just say all of her rights have been taken away, does she have some sort of reasonable expectation of privacy if all of her rights have been taken away? No. But then the answer is also, how is she going to your program if I've had to take all her rights away? Right? So that doesn't make sense either. So I think that's where I stand, but I'm happy to, if you want to reach out to me, Doug, privately or separately, I'm happy to talk about that further. Okay, hold on. I got to do this systematically or I'll lose track.
Thank you.
Of course. Of course. Thank you for the comment, Janice, the beautiful. She is a nugget. You should see how cute this kid is. She is lucky she is this cute, because she gives me grief, you know, and I know you guys know this, but every person with Down syndrome is so happy. Yeah, except this morning when I was trying to get her in the car to get her to put her shoes and socks on. Not always happy. Yep, if the parents passed. But also, I mean, not that you guys have this role with these parents, but please, please, please do estate planning. Please do estate planning. Please think through this. I do this with every single client. I want them to think through these things. This is not a shock that you're going to die one day, right? We are all going to die. I love it when clients say to me, if I die. Really? What do you know? You are definitely dying, and so am I. So there's a plan, and you can plan, and it's okay. And I get this is hard, but let's just plan for it so it's not hard. Okay. Special needs trusts and when they're necessary. Well, that's a super complicated question. I will tell you, Stetson Law School has a 5-day conference just on special needs trusts. Sonia, if you could pop in and tell me a little more specifically about that. I mean, I can tell you generally how it works, but Miss Sonia, you might want to lead me to where you want me to go. If not, I'm going to ramble a little bit. And you'll be like, that is not what I wanted to know.
No, you're fine, Catherine. Mainly my question is if there's not a lot of property involved,
Right.
Is there a need to do a special needs trust if it's just money that's already been allocated as far as life insurance goes?
Oh, nope. Then I'm back in. All right. It doesn't matter if it's property, because in your world, you think of property as like your house or something like that. You just said life insurance. Well, life insurance is property too, right? So biggest asset I have right now is life insurance. I've got in the technical term, I've got my mother would never have said that. I've got a lot of life insurance, right? Because I've got a child with special needs.
Right.
So that life insurance is automatically, or is absolutely being driven into a special needs trust for her, because she can't control that money, right? In order to be qualified for government benefits, if she were to be qualified for SSI or Medicaid or any income or asset-based program, she absolutely could not have control of that money. Also, I don't want her to, because certainly at 8, she'd make terrible decisions. But honestly, I don't think she has the capacity, even at 18 or 25, to manage assets like that. So, you know, part of estate planning when you have a child with special needs is absolutely to create a special needs trust, but it may not be a standalone special needs trust. It may be part of your overall estate plan. I have lots of clients come to me and say, I need a special needs trust. I'm like, okay, but you don't need a standalone special needs trust that then triggers this tax returns and all sorts of stuff, when right now it's got absolutely nothing in it. Because the reality is, during my lifetime, during my husband's lifetime, as long as we're alive, we're taking care of her. Really, it's only after our lifetimes does any of this come into play. So it's what happens after our lifetimes is that special needs trust gets funded. And then honestly, I like a corporate trustee to handle special needs trust because they are very, very complex. And it's very technical on how to manage them. And if you do it wrong, you could disqualify the person from benefits. That's terrifying to me. So even though your brother may love your daughter more than life itself, I don't care. Unless you tell me he's managed 100 other special needs trusts, he's out. I want someone who's an expert in this because it's very complicated. I didn't pick a friend of mine, right? I picked a corporate trustee.
Okay.
So, but special needs trusts play really, really well with ABLE. If you don't know about ABLE, there are whole presentations I can do on ABLE. I work with them on a regular basis. And ABLE and special needs trusts are very good friends. So they play really nicely together.
Okay, perfect. Thank you so much. This has been very informative. Thank you.
Absolutely. I also just want to be a resource for you guys. If you guys run into something and you're like, gosh, I don't know who would know the answer to this question. Like it's this weird, niche-y, Doug's got his FERPA versus guardianship case. I'm happy. I don't deal the education side so much, but of course I know the guardianship side really, really well. So I'm happy to brainstorm my way through it. Let's see. Lisa says, I'm from South Florida. Can I use you as our attorney, or can I choose someone that practices in our county? I will tell you, generally, I practice all over the state of Florida. There's only a couple counties I don't practice in. And if you reached out to me and you said, oh, I'm from Miami-Dade, I will tell you I cannot help you, but I'll absolutely help you find someone who loves this area as much as I do. But I do practice all over the state because that is one of the benefits of COVID is if we weren't doing Zoom law before, we certainly are now. And like I said, please, please, please go to my website. There's a ton of great information under that lowdown on law tab. Hold on, I'll put that in here, lowdown on law. I think it's up in the higher up section as well, but there's so much good information. We have all the PowerPoints. I think we have videos from some folks as well. Tons of good stuff from APD, from Social Security, it's all there. So I'm from Broward. Okay, my daughter turns 18. So there's a great attorney down in Broward. Of course, I've just blanked on her name, but Lisa, if you'll email me directly, I'll think of her name in a second and I'll just be embarrassed I've forgotten it. And I'll get you that name. She's lovely. Or again, you're welcome to try to do it yourself, right? I mean, I've given you everything. You got to get fingerprinted and background checked, but they should be nice to you. You could do it yourself, but I'm going to tell you, Lisa, you're going to do your Wings decision-making toolkit first, right? You promise? I'm waiting for Lisa to respond. Yes, ma'am. Thank you. Because guardian advocacy isn't for everybody. We don't know, right? I mean, you may sort of know, but I want to be sure. Okay. And I think that's a great exercise for all of us. I promise I will do it for my nugget when she turns 18 as well.
Catherine, while you're on this slide, you said you were going to come back to C.
Oh, that's right. Social decisions. All right, guys, am I creating any problems for you if I take away May's right to make social decisions, but then send her your way to do the UCF program? Huh? Does that cause any problems? Come on, somebody's got to reply. Come on, Doug. Am I creating problems for you if I send May over to Florida Gulf Coast and she can't make social decisions because I took it away?
No.
Yes, yes, I have.
Oh, well, I was thinking we would teach her how to do it, but
no, how is she going to come to college if she doesn't have the legal right to make social decisions?
Oh, okay. You got me.
Yeah, right. See, that's the thing. And how do you have a job, right? I've just taken away May's right to have make social decisions. How does she work anywhere?
Oh,
Part of any job is you're making social decisions too. I don't want to sit next to Doug. Doug's weird, right? I mean, you have to make social decisions. So parents, just like Janice, I think you were talking about earlier, maybe it was Iris, the hard part about some of the things we do as parents of children and loved ones with intellectual developmental disabilities is the dignity of risk. I've got to let May go do this and fail and stumble and screw up and hope that it's going to be okay, right? Just like I've done with her sisters. So if I take away her right to make social decisions, we're seeing kids get pushed back out of these programs or not accepted, right? I've also seen some programs turn down guardian advocacy generally, which I think is wrong, but that's a whole separate conversation that I'm willing to have separately. Does a durable power of attorney circumvent the individual making decisions for themselves? Dondi, I want you to think about that. You have executed a durable power of attorney to let Drew make decisions for you okay, and a durable power of attorney means it survives incapacity. So you have executed a durable power of attorney so that Drew can make decisions for you, and you're doing it as I like Drew, but in the event you're sick, you're in the hospital, you're on a trip around the world, but does that mean you still can't make decisions for yourself? No, you absolutely can still make decisions for yourself. It's not a determination of incapacity, and it doesn't stop you even from revoking that power of attorney, right? That Drew, I thought he was okay, but he's trying to steal my money. I'm going to revoke that. All right, you can. So yeah, when you guys run into this stuff, I know this sounds self-serving, but I really want information and education to be, foremost. And I'm, again, so passionate about this because of my kiddo. All right. See, now I'm going to go back to my kid's picture so you can see her again. And it's got to be my favorite one. It's that one, right? I've got to change the world. So if you guys run into stuff where you're like, wait a second, that doesn't make sense. Or how does that work really practically? If I can't help you, I'm certainly going to make sure you know who to contact. And if you need somebody local in your area, I'm happy. The elder law section of the Florida bar is wide and deep. There's lots of people who are passionate about this area. And they are, thank you very much, Miss Bailey. I agree. She is a complete and utter nugget. And I tell her that on a regular basis. So if I then call her something else, she says, I'm a nugget. I'm like, not right now, you're not. So, we're all happy to help. It's important to us that this is all done properly. I'm going to start. Yeah, you should. It's a great term. So, all right, guys, do you have any other questions for me? If anything else comes up, you have my email address, you have my phone number. Heck, stalk me on Facebook. You'll see adorable pictures and slightly sarcastic comments about having a parent of a child with special needs. So.
Catherine, thank you so much much for this wonderful presentation. I mean, so much information. I'm glad this is recorded, and I want folks to be reminded that we will send you a link to our YouTube channel where this will be posted sometime probably tomorrow. And I also want to let you know that we have posted an evaluation for the webinar, and that was the bit.ly FCSUA webinar April 2022. And there's a bit.ly address that Janice Seabrooks Blackmore posted. And if you could please complete that evaluation to let us know what you think of what Catherine said today, whether you think she really knows what she's talking about. I'm not sure. Now, I know.
Well, I was trusting Drew with all sorts of financial decisions. So clearly that was a mistake.
I do know, and I appreciate so much because you have shared so much very valuable information and so many options that folks can share with families, and you've made yourself available, and we greatly appreciate that. And so at this time, we will bring the webinar to a close. And again, you can reach us if you have any questions. We'll be posting the PowerPoint presentation, which has Catherine Davey's contact information. And so you'll be able to review this as many times as you would like. to really get this clear, because that is a lot of information in this past hour. But thank you so much.
Thank you,
Dr.
guys.
Janice, do you have anything else to share before we leave?
No, it's just really, I really like the way that you shared the content, Catherine. I like your calling out names and helping everybody stay attentive, so that it can be real, because this is an area that comes up often.
Yep.
When we are together with our folks at our institute, and you know, from the last time that you presented to us, there were questions all over the place. And so we knew,
Absolutely.
yeah,
It's-
we knew it's gonna be something that people need to revisit over and over again. And I just really like the way in which you present the information. Thank you.
My pleasure, guys. Have a great afternoon.
All right. Bye-bye.
Talk to you soon, everyone.
Bye-bye.